Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
Thank you, Ashley. Good afternoon, everybody. Again, as Ashley mentioned, I'm Mike Bender with K. Bender Rembaum, Community Association Lawyers. For those on here who are not quite familiar with us, we are a law firm that dedicates our representation to community associations. We have offices in Broward, Palm Beach, Orlando, and Tampa, as well as in Miami-Dade by appointment. We are 21 attorneys. 11 of us are board certified specialists, and we assist our clients in all aspects of community association representation. We also actively participate in the legislative process on behalf of community associations, and as like today, offer a lot of education to all of you, and happy you're here. I do want to start off by letting you know that what I'm talking about today is for informational purposes only. I'm not giving legal advice. If there is anything that you will need further, if you need specific legal guidance, you'll need to contact your association counsel. And certainly if you are in need of additional or new counsel, I might know a good one. So, but with that, I do want to remind everyone this is informational purposes only. It is the 2023 legal update. So what that means is I'm going to be giving a review of what legislation passed in 2022 that the state says we have to talk about. And not surprisingly, a large majority of this class is going to be about Senate Bill 4D, which is which I'm sure a lot of you know is the construction bill, milestone inspection and structural integrity reserve study bill. With that, I'm going to share my screen and we're going to get started. And hopefully I'll do this right. Did I do it right?
Perfect.
Great, thank you. I did want to see, how do I, give me 1 second, people. Oh, it would be here. Trying to see how I would be able to open the Q&A, Jeff, so that if people are asking questions during the class, I can.
Yeah, just hit the Q&A button at the bottom.
I know, it's not showing me that right now.
Oh.
Okay, I'm going to stop sharing for a second. I'm going to open this up first. Move that there. Let's see.
Oh, yeah, you have to hover over. I got you. I see what you mean when you're sharing. While Michael's doing that, China, I see your question about the, we see it. And China, the handouts will be available for download on the evaluation page. There'll be a link at the top to download the slides later.
Okay, so you guys, everyone can see just the presentation, right?
Correct.
Okay, great. All right, thanks, Jeff. All right, so, well, and to start with, I do want to go over a couple of quick items that are not on the in the presentation that you'll get. Two items that I noticed were not in there that I wanted to make brief mention of. The first one, this is a law that took effect July 1st, 2022, and it was a change to 718 and 720. And I realize we didn't actually up front ask who's who's in a condominium 718 and who's a condominium and who's in the 720. HOA. And so I will be letting you know up front where things apply. If for some reason I don't say that, you can presume it applies. Hi, Annette. You can assume it applies to the 718, 719, and 720, the condo co-op and HOA. So, but this particular change only is in 718 and 720. I don't know why they didn't put in 719. But that's probably forthcoming. And it was really just to add, if you recall, that there is language in the statutes that allow the display of flags. And you were allowed to, and owners were allowed to display in a respectable way a portable removable official flag. that represented the U.S. Army, Navy, Air Force, Marine, or Coast Guard. They have now added Space Force. Do know that if someone has a Space Force flag flying, that's not larger than 4.5 by 6 feet, that is allowed by statute. The other item, which is part of Senate Bill 4D, and that was a separate Senate Bill 438. Senate Bill 4D provides one particular section before I get into the meat of it, and that is, which is the milestone inspection, the structural integrity reserves. This has to do with if an existing roofing system or a roof section was built, repaired, or replaced that's in compliance with the 2007 Florida Building Code or any subsequent edition of that code, and 25% or more of the roofing system is being repaired, replaced, or recovered, only the portion being repaired, replaced, or recovered is required to be constructed in accordance with the Florida Building Code. Okay, this was now is being incorporated into the Florida Building Code, and that's relevant because prior to this provision, prior to this law taking effect, and by the way, this took effect May 26th of this year. Prior to this taking effect, if more than 25% of your roof was being repaired, replaced, or recovered, the code required 100% of the roof to be repaired, replaced, or recovered. And this is, this, in my opinion, and I believe it's supported by facts, is directed at the insurance situation, in particular in a single family home situation than the in a condo. But because what it's doing now is if you do have instead of having to replace your entire roof with 25% is damaged, you're only having to replace that portion of your roof. And so insurance claims presumably would be reduced because of that. But that was a significant change in the Florida statutes. It took effect May 26, 2022. And so please be aware of that. Okay. Now let's get into this. Why am I not able to move this along? There we go. You guys are seeing that? Yes? Good.
Correct. Yes.
Okay. All right. So now we're going to get into Senate Bill 4D. And this is the milestone inspection. The first part I want to talk about is the milestone inspection. And milestone inspection means a structural inspection of a building, which includes an inspection of load-bearing walls, primary structural members, and primary structural systems. One thing what I will never not to do is read the slides. For those of you who are watching, you can read them along. As Ashley and Jeff both mentioned, we will be providing a link to this slide presentation, so you will be able to have this on your own computer. You'll be able to print it out and have it available to you. So I'm not necessarily going to read verbatim, or at least try not to read verbatim all of the slides. Some of them, obviously, it's relevant to do so. But I want to just talk about, so Senate Bill 4D had two main parts. And I want to start by, I want to back up and say that, as I'll get into this a little bit more, the milestone inspection and the structural integrity reserve study are the two big parts of this particular piece of legislation that were passed in May at special session and are the law of the land, if you will, now. And I'll get into the deadline dates, and I'll get into who it applies to, who it doesn't apply to. And I will, as questions come in on some of these things, to the extent I can get to them or tie them into what I'm talking about, I will certainly do my best to answer them. And so just bear with me on that. So regarding the milestone inspection, the inspections are to be carried out by a licensed architect or engineer that's authorized to practice in the state of Florida. And the purpose of the inspection is not to determine if the condition of an existing building is in compliance with the Florida Building Code or the Fire Safety Code, but it's to attest to the life safety and adequacy of the structural components of the building, and to the extent it's reasonably possible, determine the general structural condition of the building as it affects the safety of the building. including necessary maintenance, repair, or replacement as needed. Okay. A condominium association under Chapter 718 and a cooperative association under Chapter 719 must have a milestone inspection performed for each building 3 stories or more in height. So if you are a 1 or 2 story building, the milestone inspection does not apply to you. Okay. And I've seen a couple of questions already. I want you to I do want to let you know that there are the bill, while putting in, again, my opinion, a lot of, especially with regard to the milestone inspection, sound policies. There are several questions that need to be clarified on both sides of the bill. And when I say both sides, I mean the milestone and the reserve study. And with the milestone inspection, one of those questions that we're seeking clarification on is exactly how they define a story. Is it 3 stories above ground? What if you have a 1 story that's built, below deck, so to speak? If you have a 1-story garage and then 2 stories of residential, is that still considered 3-story? Seems like it would. But these are questions that have been posed and clarifications that are being sought between the Florida Legislative Action Committee, which is the committee that I've been on for years through CAI, and through a subcommittee of the Florida Bar. There are a lot of good minds, very good minds, working on putting together questions or concepts to address what we can call technical corrections, although I think some of them roll into some substantive corrections in what would be called a glitch bill. Ronnie Dremmer, you're asking if changes will occur sooner. Are we stuck with 4D? I think there'll be some changes. I don't think that as of right now, I would not expect the deadlines to be pushed back. I think December 31st, 2024, which is when the milestone inspection must be completed, with a few exceptions that I'll discuss, and the structural integrity reserve study needs to be completed, and I'll be getting more into that. So I would go into this, if you're board members and managers, I would go into this, and even and interested owners, I would go into this with the expectation that those are your deadlines, and you should be proactively communicating with your professionals, your engineers, qualified engineers or architects, to get in their queues for getting these inspections and these reserve studies done. But if you are 3 stories or more in height, you must have this milestone inspection. It must be completed by December 31st of the year in which the building reaches 30 years, based on the date of the CO, that your certificate of occupancy, your building was issued. And then it's 10 years following initial inspection. Okay. If you're located within 3 miles of a coastline, the condominium or cooperative association must have it performed by December 31st of the year in which it's 25 years, and then it's 10 years thereafter. That's another question. How does coastline? Coastline does have a definition, but it still raised some questions, and that is still another area that they're looking to clarify. Session starts in March of 2023, so it's rapidly approaching. So we'll see some, and I can tell you that there are those 2 groups I talked about are working on proposing some legislation to Tallahassee for them to be considering, and when they go into bill drafting in the next couple of months. Okay, the association is the party responsible for ensuring compliance with these deadlines, as well as for the costs associated with this inspection. Okay, so now here's where I want to get into just a little bit of the dates. If your certificate of occupancy was issued on or before July 1st of 1992, okay, which would be now, you'd be past your 30-year already, then your building's milestone must be performed by December 31st, 2024. So that's what there's, so basically, if your building was built in 93 or 94, you're 30, and you're not on the coastline, keep that in mind, then your 30 years would be up this year or next year, and your deadline date of 2024 is in play. If your deadline already passed, if you're already past the 30-year, then you have till December 31st, 2024 to have that milestone inspection completed. And if you're unsure, and that date it should be the date of issuance of the certificate of occupancy. And if for some reason that's not available, then the date of occupancy evidenced in any record of your local building officials. And those are questions and those are issues you would follow up with your engineers, your business advisors, your management team, your engineers, and then lastly, I wouldn't say lastly, but also if you need your association counsel to get involved and provide you confirmation of that date. Okay. Once it's determined that you need that inspection, and the agency is providing written notice of the inspection by certified mail return receipt requested, you have 180 days to complete phase 1 of the milestone inspection. Okay, so let's talk a little bit about phase 1 of this milestone inspection. Okay, for phase 1, a licensed architect or engineer, a Florida licensed architect or engineer that's authorized to practice in this state has to perform a visual inspection of the habitable and non-habitable areas of the building, which include the major components of a building, and they're supposed to provide a qualitative assessment of the structural conditions. If they find no sign of substantial structural deterioration, which I will get to further explain that in a minute, if they find no signs of substantial structural deterioration to any of the components that under their visual examination, keep that in mind, visual examination, then you don't have to move on to phase 2. Okay, and I'll talk about phase 2 in a minute as well. An architect or engineer who completes a phase 1 milestone inspection must prepare and submit the inspection report. So the visual inspection is what phase 1 is, and I guess the question that I've heard posed, I've done a few panels and I've had different engineers on these panels, and I've heard the question posed to them about the likelihood of them signing off on a visual inspection. Universally, the answers I've been given is it seems unlikely. Now, and the engineers on listening, or if you're talking to your engineer personally about it, to me, it seems like it's a significant ask to obviously these are qualified licensed engineers, to be able to do a visual, just eye the buildings and be able to say that everything is good. Now, there are certainly exceptions to that, and some may do that, and they have to, because they do have to put under seal in writing that everything is good and they don't need the phase 2 inspection. So I'm going to presume that for the most part, phase 2 inspections are going to be addressed, are going to be required almost uniformly. And Betsy, this does not apply to 720 communities at this time. This milestone inspection does not. If you are in Broward or Miami-Dade County, you may still have a 40-year certification requirement even though you're a 720 community. Okay. Phase 2 of the milestone inspection must be performed if any substantial structural deterioration is identified during phase 1. Okay, now a phase 2 inspection may involve destructive or non-destructive testing at the inspector's direction, and this inspection may be as extensive or limited as necessary to fully assess the areas of structural distress. In order to confirm the building structurally sound and safe for its intended use. The inspection will also and can recommend a program for fully assessing and repairing distressed and damaged portions of the building. The statute does provide, when determining testing locations, the inspector must give preference to locations that are least disruptive and most easily repairable while still being representative of the structure. I mean, to me, I think that's the kind of thing that any qualified inspector is going to be doing regardless, but they did add that in the statute. And again, much like exactly like the phase 1 inspection, an inspector who completes phase 2 must prepare and submit an inspection report. Okay. Upon completion of the phase 1 or phase 2 inspection, the architect or engineer who performed it must submit a sealed copy of their inspection report with a separate summary that at a minimum has material findings and recommendations in the report to the condominium association or cooperative association and the building official of the local government which has jurisdiction. Okay, so they have to submit a sealed copy of their report, 100, 200-page report, whatever that may be with their, but they also are required to do a separate summary, and that summary is what's going to contain the material findings and recommendations. And the reason I pointed out that's relevant is because that was you know, I heard people say, hey, you know, these things got put through without any input, and my answer to that is, this was not a bill that, in my opinion, was necessarily "quote unquote" rushed through, because it was discussed since, you know, 6, 7, 8 months prior to the 2022 session. I think what happened in 2022 regular session was there was a lot of pushback between the House and Senate as to the reserve portion of the bill. In my own opinion, and what I viewed is the legislators got caught up in cultural issues, and they spent a lot of time dealing with those, and session ended before there could be a compromise. The special session on insurance popped up, and they recognized, I think Tallahassee got a lot of negative pushback that there was nothing addressing the post-Surfside tragedy, and so they were asked to they were asked to look at it again during that special session, which they did. I think they definitely heard from engineers, architects, reserve advisors, property managers, lawyers, CPAs, industry, volunteer leaders. I think they heard from all of these groups. I don't think they always listened, but they heard. One point where they did listen, though, was they initially the bill initially was going to require that the entire report be mailed to all owners. And that is something that would potentially cost some associations an enormous sum of money. These reports can, like I said, be 100 or 200 pages with a lot of information that, to the layperson, I include myself in that group, may not be fully understandable, or may be misread in a way that could be good or bad. But the enormous expense of having to mail out these reports to a lot of people who may not even open them was something that we discussed. And that's where we asked that they incorporate the idea that the inspection report provide a summary, as it showed on the prior slide. So that summary is now what needs to be, and I'll reiterate that in a moment. That summary is what will need to now be sent out to all owners. The full report, along with the summary, will need to be on your website. If you have a website requirement, the full report, along with the summary, will both need to be put on the website, but the summary is the only thing that has to be mailed out. And here's what the inspection report must, at a minimum, meet. And this is why, you know, the signature and seal or electronic signature of the engineer or architect performing it, the type of inspection report, and identify any substantial structural deterioration. And I put on the bottom of this slide, the definition of substantial structural deterioration is substantial structural distress that negatively affects a building's general structural condition and integrity. Okay. And to clarify this, the term does not include surface imperfections such as cracks, distortions, sagging, deflections, misalignment, signs of leakage, or peelings of finishes, unless the licensed engineer or architect performing the inspection determines those imperfections are a sign of substantial structural deterioration. So again, there's a lot of emphasis being put on the qualified engineer's ability to ascertain what would be considered substantial structural deterioration and require further follow-up, and what is just imperfections, which is more cosmetic perhaps, and should be proactively addressed maintenance-wise, but not going to be something that would come under the milestone inspection report. Okay. The report will state whether unsafe or dangerous conditions were observed, as those terms are defined in the Florida Building Code. And there's the recommendations for any remedial or preventative repair for any items that are damaged, but not substantial structural deterioration. So that's a good thing. I mean, if you have substantial structural deterioration, you want to know about it, and you're going to have to address it as part of the milestone inspection timeframe. But that report will also have recommendations on remedial or preventative repairs for items that are more of the imperfections, that are damaged but not substantial structural deterioration. It'll also, of course, identify any items that might require further inspection, and those will then need to be followed up. There we go. Okay, now local government enforcement. Here's another area that needs clarification. The statute as passed provided that a local government and local enforcement agency may prescribe timelines and penalties with respect to compliance with the milestone inspection requirements. I mentioned earlier the deadline, December 31st, 2024. Some municipalities, and I guess let me just back up a tiny bit and just remind everybody, if you're listening here from Broward or Miami-Dade, you're familiar with the 40 years recertification and then your 10-year, 40 plus 10. The rest of the state, those are the only two counties that had this requirement. Prior to May of this year, the only two counties that had these types of inspection requirements were Broward and Miami-Dade. So local agencies may have had some certain requirements throughout the state, but generally speaking, it was not statewide. This bill, now this law, does make this inspection requirement a statewide requirement. However, it also had language in there deferring to local government agencies and allowing them to prescribe penalties with respect to compliance with milestone inspection. The understanding, from my point, and I think from a lot of people similarly situated as me and who were involved in this, was that that meant that the compliance dates as set forth by state law are the compliance dates. And if communities in a particular jurisdiction, whether it's the county oversees it or whether it's city municipality overseeing it, if compliance was not timely obtained, the state was basically granting the authority to these municipalities, local government, to enforce and ensure compliance by way of appropriate penalties. It was not meant to say that these local municipalities can decide when they want compliance. And I was made aware that there was one county in the northern part of Florida, and I believe at least one city in the southern part of Florida, whose local government agencies were sending out letters saying, hey, your milestone inspection, here's your 180-day notice, do your milestone inspection now. And that kind of threw everybody for a loop. And so that's something that is hopefully going to also be addressed in 2023, the quote unquote glitch bill, to clarify the timeframes that the state has provided are the deadlines, and that the local government enforcement agencies, counties or cities, are able to then ensure that if compliance hasn't been achieved by the deadline dates, that they can then force compliance by way of reasonable penalties. Okay. Okay, if an association fails to submit proof to the local enforcement agency, repairs are scheduled or commenced for substantial structural deterioration identified in a phase 2 report within the required time frame, the agency must review and determine if the building is unsafe for human occupancy. And we've seen a little bit of that. I know there was just a recent one down here in Miami Beach. I think it was Miami Beach. Apologize if that's giving the wrong city, but where they basically found a structural beam that was deteriorating, and they said everybody had to vacate the building. And I think that's happened at least 2 or 3 times. And it might have happened in other areas of the state of which I'm not familiar, but so there is definitely a proactive approach being taken, and all of you listening, managers, board members, interested owners, need to be aware of this need for proactivity, not reactivity. I think that's the biggest takeaway from Senate Bill 4D, is that the state is governing that they want more proactive approach, not reactive. In their opinion, that will help avoid another Surfside-like tragedy. Okay. Here is the board's duty after obtaining the report. Okay. You must distribute a copy of the inspector-prepared summary to each unit owner, regardless of the findings or recommendations, and that's by U.S. mail or personal delivery, or you can email it to any owner who has consented to receiving notices from the association by way of email. You must also post a copy of the summary in a conspicuous place in the condominium or cooperative property where you'd basically the same place you'd post board meeting notices or membership meeting notices. And you must publish the full report and the summary on the website if you're required to have a website. If it's not a statutory requirement for you to have a website, but you do have one, I would say post it there anyway, but that's your discretion. Let me quickly see if we have any questions that I can tie in. Bud, like I said, if you are a two-story complex, the milestone inspection doesn't apply, but because you are in Broward County, the 40-year inspection may still apply. And so you will definitely need to follow up with your local authorities, Broward County. You can follow up with your local council as well. Barry, that is a open question. Barry asks if an underground parking garage is less than 12 feet from the concrete ceiling to the first floor, is that a story? Well, I know you don't expect me to answer that, Barry. You're just kind of putting that out there to say this is the kind of clarification we need, and I agree with you. Okay, Robert Alter says, when is the date the first structural reserve study must be done? And the final date. Okay, so Robert, again, if you are required to do a milestone inspection, oh, I'm sorry, you're saying the reserve study. Okay, I'm going to hold off on the reserve questions because most of these questions are about reserves, so that's why I'm going to come back, circle back to them when I get to the reserve studies. All right, let's go back to. And is there a standard template for the milestone inspection report? That is a question to pose to the engineer architect that you should be or architects that you should be interviewing to obtain that. Joseph, to clarify, this is for 3-floor and above buildings, condos. Yes, sir. The milestone inspection that I'm talking about now is if you are a 3-story or above building, condo or cooperative. Robin, can the report summary be emailed instead of in postal service? If the owner has consented to receiving email as the way of doing your meeting notices and other notice packages, then and their email address is then part of the official records, the report can be emailed. If those owners who have not done that have to have it mailed to them or personally delivered. Gene asked, will there be a discussion on condos less than 3 stories? Gene, with regard to the milestone inspection, there is no discussion less than 3 stories because it doesn't apply. As I said, if you are less than 3 stories and you're in Broward or Miami-Dade, you should be communicating with your local authorities to determine whether you have a 40-year certification requirement. When I get into the reserves portion, I will be talking a little bit about if you're less than 3 stories, the differences. Yes. Jonathan asked, do they need to stay posted indefinitely like a permit? As far as the reports, Jonathan, that is an open question. That is not anything. They are required to be maintained for 15 years. And since you're doing these every 10 years, I'm not really sure why they came up with 15 years. So I would say that you're maintaining as part of the official records for 15 years. Keep them posted for 15 years. Just have a folder for them. Lori, are there legislative changes pending that could affect the decision to proceed with the milestone inspection? I am not aware of any changes that would affect the decision to proceed with the milestone inspection, other than clarifying what is required in the milestone inspection, as I'm going to get into that in just a moment. Okay, let's move back. Okay, and as far as the county certification requirements, there were some discussions. I know Miami-Dade had had proposed a 30-year to reduce theirs to 30 years, and to my knowledge, that was not formally approved yet. I think it was under readings. Broward, I'm not aware that Broward had approved a reduction yet. So it's possible, but that is something to check as far as whether the 40 is now 30. I am aware of many communities we work with in Broward who are still being contacted to do their 40-year certifications. So that is something that would need to be looked into. Paying for the milestone inspection. Pursuant to 718-112 Florida statutes, if an association is required to have the milestone inspection performed, they must arrange for it and pay for it, all costs associated with it, as we talked about. And this is now this next slide. If the officers or directors of an association willfully and knowingly fail to have a milestone inspection performed, such failure is a breach of the officers and directors' fiduciary relationship with the unit owners. Now, I want to point out a couple of things. Number one, this is something that's being discussed to ascertain exactly what the point and purpose of this is in Tallahassee, and so that we can better clarify it either in Tallahassee or when we're talking about this with all of you. But I also want to point out that in this particular provision, it is a very, very high threshold. The officers and directors have to have willfully and knowingly failed to have the inspection report performed. So that is a very high threshold, and I will offer this, again, not legal advice, just informational, but I would say that if you are required to have the milestone inspection, you should be proactively trying to schedule it to get it done. And if you are doing that, in my opinion, you're not willfully or knowingly failing to do it. If the engineer, there's questions about the labor force. Are there enough engineers out there to get these things done by the deadline dates? And if that is an issue and you're unable to secure one in time, to me, that is not knowingly and willfully failing to have it. You are proactively trying to get it done. So just be cognizant of this provision. And like I said, I personally don't think this should have while I wasn't necessarily thrilled to see the way they put this in. It's a little bit of a scare tactic, in my opinion. And I think, but I believe that maybe I'm a little naive here, but I believe that if you have a legal requirement, officers and directors are going to make efforts to comply with those legal requirements, especially when it comes to the safety and soundness of the building and to protect their residents, which includes them quite often. That said, this is there, and officers and directors need to be aware and need to proactively be sure they are doing what they need to do to get the job done. Okay. Manager, they added language for the manager as well. So the manager must comply with the requirements of performing such inspection as directed by the board. Again, not 100% clear the way they wrote it. The way my takeaway from interpreting this is essentially similar to manager is going to assist a board with proactively trying to be in compliance. A board is going to offer guidance. And the manager is not going to do anything that would otherwise hinder the ability to get the inspection report. So much like any other, responsibility of the management company when working, when assisting clients with contracts, the job here is the same. So, I don't need to spend much more time on that, I don't think. For clarity, the otherwise required milestone inspection does not apply to the single family, 2-family, or 3-family dwelling with 3 or fewer habitable stories above ground. So there's basically single family, 2-family, and if you're a 3-family dwelling, but you have 3 or fewer habitable stories, it's not going to apply to you. Okay, here's some of in my opinion, a little bit of the confusion on the timing, because the statute does require the Florida Building Commission to review the milestone inspection requirements and make recommendations to the legislature to ensure inspections are sufficient to determine structural integrity. And they're supposed to provide this report by the end of this year. And they're supposed to then consult with the state fire marshal to provide recommendations to the legislature for adopting comprehensive structural and life safety standards. And that's supposed to be presented by the end of next year, December 31st, 2023. So I have personally not heard a good answer as to why those deadline dates are there and how they impact the deadline dates for the milestone inspection. And I know the opening question, someone asked if I'm going to talk about ELSS, and no, that's not part of this legal update. So I'm not getting into the ELSS requirements, but I will say that as of today, the ELSS, Emergency Life Safety System requirements, still have a deadline date of January 1, 2024 or December 31, 2023. I guess it's basically the same, essentially the same. And so I am not aware of there being any discussions about pushing that deadline out further. That's not to say that come next month or a couple of months when they start getting into bill drafting or getting up there and hearing, and by the way, hearing from all of you as to your concerns as to the timing of all of this, especially if in the condominium world and some of the cooperative world, but in particular the condominium world, where there is the ELSS requirement, where there is this new structural integrity reserve requirement, along with the milestone inspection, where you have other requirements pertaining to AEDs, the defibrillators, as well as elevator, certain things with the elevators. So there's a lot of different expenses that are all coming due at once. And so I was talking with a group out in Margate, and they put together 86 signatures, and I recommended that they send that to their local representatives, send it to the governor's office. And they did, and they also they shared it with me so I could share it with our lobbyist at FLA, who can then also share that up in Tallahassee. And that these are the kind of true life issues that the legislators in Tallahassee do need to hear, and sooner than later. Like I said, whether that moves the needle, I can't promise you that. But if you're looking to help them understand, because a lot of them don't live in the condominium world or work in the condominium world. So to help them understand the true impact that this could have, not to mention the insurance situations that we're all facing, I recommend that you put something in writing and send it to your local legislators, send it to the governor's office. Okay. Before I jump onto that, any other questions about the structural integrity reserves? Just give me 1 second here, because I want to just find one thing that I want to talk to you guys about. Because there's been a couple of questions on this, and yeah, so the issue with the structural and the milestone inspection, let me just make sure I did. I really want to be able to answer as many of your questions, so it's a little easier to free flow when these are done live, guys. Teresa asks, how soon before the building reaches year 25, and I presume you're on the coast, can we do the report and submit? I don't, that is not something that they've addressed in legislature, but in my opinion, if you've already reached year 25, then you can do the report and submit it at any time. There is there's a loophole, if you will, in the way the language was drafted, which is one of those items that I will consider a technical correction, which is going to be or should be addressed, which I mentioned earlier, that if you were built prior to 1992, this bill says that your report's due by December 31st, 2024. It was referencing the 30-year, but it doesn't likewise talk about the 25-year. So if you're already at year 25, you can go ahead and do that milestone inspection report and submit it, anytime. So long as it's a qualified engineer or licensed architect, and so long as they are meeting all the necessary requirements of the milestone inspection report. Okay, China asks, a condominium going through the 50-year recertification, would that meet the requirement of the structural inspection? Maybe. And I do not like saying maybes, For those of you who know me, have heard me teach or work with me, as counsel, that I'm not a maybe kind of guy or it depends kind of guy. I mean, I try to at least give options and then, recommendations. But in this case, what I have preached, preach is the wrong word, what I've been saying and what I've just confirmed and discussed with others is that if you've recently done the 40-year and or 50-year, you need to contact the engineer that you're working with. And presumably that engineer would be licensed to the milestone inspection, and you need to pose these questions to that engineer. You need to ask the engineer, okay, so what more, if anything, do we need for the miles to comply with the milestone inspection? While you're doing this, let's get that all done at once. If you've already completed it, what more do we need to have done in order for that report you've done to comply with the milestone inspection? So let's get that done and have you sign it. And that should be significantly less than having to obviously start from scratch. So these are good, good questions you guys are asking. And that's my suggestion. My recommendation there is contact your professionals, your qualified engineers, and ask them, how do we make sure what you're doing complies with the statute as it is today? Because in my understanding, the fact that you've done a 40 or 50-year recertification recently does not automatically mean that you've met the requirements for the milestone inspection, in particular, the disclosure requirements. Because the reports that you had done or are having done likely didn't have the summary that we talked about earlier that the milestone inspection requires. And they weren't necessarily published to the membership the way they need to be. So those items will still need to be addressed. The content is one aspect, absolutely, that needs to be addressed to make sure it complies with the milestone inspection, but also the manner of the report, as well as the manner of delivery of the report needs to be addressed. Okay, let's see. Barry, glitch bill recommendations are of a technical nature. That's the party line, if you will, at the from the bar side. At least as I understand it. John asked if there are obvious signs of concrete cracks, spalling, exposed rebar, rust leaks. Will that be enough of a signal substantial structural deterioration is a problem? John, I mean, the way you're writing that, it certainly would seem like the answer would be yes, but that's not a legal question. Understand that. That's a question for the engineer to address. Robert asks a good question. For clarification, association bears the cost of inspection in a multi-condo composed of separate phases that will cost, well, this is how you wrote it. In multi-condominium composed of separate phases that will cost the association apply only the phase that require the inspection and their finances. Robert, that is a question you're going to need to follow up with your legal counsel. I have a couple of different communities that are set up. There is language in the statute that allowed that if there was certain procedures taken, that finances might be shared. Generally speaking, in a multi-condo, the finances, the expenses for a particular condominium, like a roof for that condominium, for example, would be that condominium's expense only. But if you'd have to talk to your association counsel and get confirmation of how that would work in your community. Okay, Star, I've answered that question about. I don't know what the DBPR is doing or not doing, but I think that you need to get with your engineer. Is there anything coming for condominium single floor attached units as far as inspections go? Not to my knowledge. Brian asked if the association is finishing up the 40-year, do I still need to do the milestone? Address that. Teresa says, is it truth the law still unclear on inspection deadline delay? I'm not really understanding how you wrote that, Teresa, but I think you're asking, are they going to be pushing back the deadlines? And like I said earlier, I am not I have heard no discussion that would push deadlines back as of today. So you should consider as of today, these are the deadlines in place. And if they do decide to make some modifications, well, that would be, for most people, I think, a happy thing. Okay. Les asked if I think there'll be any special session before the spring session to clarify these questions sooner. Les, that is, I love that question. I will tell you that I believe there's a special session that's going to be scheduled in December but again, it's for the insurance situation, quote unquote, that we're facing in the state of Florida. I remind everybody, May was a special session on insurance, and this bill got passed then. So I don't think that any of these questions will be addressed at that special session, but I don't have any, and I say this respectfully, I don't have any magic 8-ball. I don't know though, but there is a special session I'm told will happen in December on insurance. So we'll keep our eyes and ears out for that. Okay. Sorry, Rose. Rose wants me to move the presentation along. But Rose, if there are questions about a particular section, then I really would prefer to address them then as opposed to circling back after when it's sort of gotten lost. But I will do my best now. So now I'll move on to the reserve study portion. Okay, Structural Integrity Reserve Study, or SIRS. So when I say SIRS, you'll understand what I'm talking about. It is the study of the reserve funds required for future major repairs and replacement of the common areas based on a visual inspection of the common areas. That's applicable to all condominiums and cooperatives 3 stories or higher. So that's important. What we're talking about here with the SIRS is, again, for condominiums and cooperatives 3 stories or higher. Okay. The SIRS must be completed at least every 10 years after the condominium's creation for each building that's 3 stories or higher in height. Okay, and now at a minimum, this is what's required. Okay, in the study: roof, load-bearing walls or other primary structural members, floor, foundation, fireproofing and fire protection, plumbing, electrical systems, waterproofing and exterior painting, windows, and then this catch-all: any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to replace or maintain that item negatively affects the items listed in subparagraphs A through I, which I just listed. Okay, as determined by the licensed engineer architect performing the visual inspection portion of the Structural Integrity Reserve Study. So I know there were a couple of questions about this. I can tell you right now, when we saw this come out, there were immediately questions about foundation and windows. And so the question on foundation was obviously how would you determine a reserve feature for the foundation of a building? You're hopefully never ever going to have, I mean, if the foundation is requiring replacement, you're looking at knocking the building down and putting up a new building, is my understanding. So there's been some discussion. In fact, I was involved in some discussion with the subcommittee yesterday in trying to clarify the concept of foundation and perhaps being a deferred maintenance related item, where if portions of the foundation need some work, that's where you'll reserve for that, because it would be in excess of $10,000. But we'll hopefully get some clarification on that. The other one was windows. And the big question there was, hey, in our association, the owners are responsible for the maintenance of the windows. So why should the association be reserving for the windows? I have the same question. So that is another area that needs clarification. Some possibilities perhaps are adding language that indicates windows to the extent that the association is responsible for maintenance of those windows. Seems like a simple fix because there are common element windows that the association is responsible for. And I'm not going to debate whether windows are related to the structural integrity. Obviously, if the windows blow out, you're certainly going to potentially impact the structure of the building. So I think it's because that was some other things that people were wondering why that was included. Similarly, with plumbing and electrical, do they have immediate impacts on the structural integrity and the safety of the building? Again, it's outside the purview of a lawyer, in my opinion. But an electrical fire certainly could impact. And I have some clients who have some major. I saw someone ask a question earlier about plumbing and how they had all this cast iron pipe, and that's what I've seen happen in a few communities where there's millions of dollars worth of pipe issues that if they were to burst, that would be a significant situation in that building. So that's the minimum requirements right now for the structural integrity reserve study. Okay. The vision, now you heard me say that it's a visual inspection first. The visual inspection portion of the reserve study must be performed as of right now by an engineer licensed under Chapter 471 or architect under 481. Okay. And that's important because that's one of the, there's been some, I'll say pushback or concern in the state. In particular, you have reserve study advisors, very qualified, experienced reserve study advisors who've been doing this type of work for decades in the state, who aren't necessarily licensed engineers or architects. And the way this has been written up, they would be excluded, if you will, at least certainly from the vision, the first part. And so there is some discussions being held with internally with those groups as well as with Tallahassee as far as exactly how we've better clarified. Not to mention, as I mentioned earlier, the labor pool requiring giving another task to these engineers or architects on top of these all this other work. I will offer this practice hint, if you will. If you have your engineer out there doing the milestone inspection, discuss with them about doing phase one, the visual inspection requirement for SIRS at the same time. There is certainly overlap, significant overlap. And to the extent you can have them both done, I would see an economy of scale thing as well. So if you haven't already, then you should discuss that option with your qualified licensed engineer who is going to be doing your milestone inspection. At a minimum, a structural integrity reserve study has to identify the common element areas that are being visually inspected, state the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense, and provide a recommended annual reserve amount that achieves the estimated cost or deferred maintenance of each item, element area being visually inspected by the end of the estimated remaining useful life. That's a lot of words, which to me is not very different than the way the statute read prior to this with regard to reserves and reserve studies and how you ascertain. Because I want to remind, and again, this is 718. This is the condominium world we're talking about here. Under 718, the law has provided that a board will adopt a budget with fully funded reserves. And if the board wants to allow for less than fully funded reserves, that's when it would go out to the membership and ask the membership to approve something less than fully funded, whether it's partial funding or waiving. And we're going to get more into that a little bit. But how reserves had to be, how you ascertained what those amounts were for your reserves is essentially the formula that we're reading here. I'm not going to nitpick words, but essentially, you have to determine the estimate. You have to determine the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense in order to determine how much you need to put aside. So example, if you have a roof that has a 10-year remaining life and it's $100,000 to replace that roof, in order to have the reserve would reflect $10,000 a year would need to be reserved to have that fully funded at the end of the 10 years. And that example may come back around later. Okay, so anyway, so that's that portion there, okay? And the amount to be reserved for an item is determined by your most recent structural integrity reserve study. And again, that must be completed by December 31st, 2024. Okay? If the amount to be reserved for an item is not in your most recent structural integrity reserve study, which is likely your initial one, or you haven't completed it yet, The amount must be computed using a formula based upon estimated remaining useful life and estimated replacement cost of deferred maintenance expense, which to me sounds very much what we just talked about. Okay. The key here is if you have the reserve study is going to point these things out. If you haven't done the reserve study, then you need to have a formula that reasonably determines estimated remaining useful life and estimated replacement cost. And I will just offer, again, practice tip. If you've not had a reserve study done in more than 2-3 years, you should be having one done, whether you're required to have a SIRS or not. I do want to then get into a couple of things about the timing that it talks about here. The structural integrity reserve study must be completed by December 31st, 2024. So similar to what we talked about earlier, I would discuss with your engineers, with your reserve study advisors, timeframes, get quotes, get bids now. Do not wait until 2024 to do that. Start working on that process now. Okay. If the condominium building is less than 3 stories in height, the legislation provides that in addition to annual operating expenses, the budget must include reserve accounts for capital expenditures and deferred maintenance. These accounts must include, but are not limited to, roof replacement, building painting, and pavement resurfacing, regardless of the amount of deferred maintenance expense or replacement cost, and any other item that has a deferred maintenance expense or replacement that exceeds $10,000, which is very similar to the original language that we're all familiar with. So if you are less than 3 stories in height, and this goes back to the question someone asked me, are you going to talk about less than 3 stories in height? The answer is the SIRS, you're not mandated to do a SIRS, but your requirement to do to have reserves as part of your budget absolutely remains. So in other words, if you are less than 3 stories in height, your legal requirements are the same today as they were prior to May of 2022 when this was passed. So what that means is when you're proposing a budget, you have your operating expenses, and you should have what your reserves would be for the roof, the painting, the pavement, and any other deferred maintenance item that's over $10,000, what it would cost to fully fund those as one portion. Now, then, as we'll talk about a little bit later as well, if the board of that less than 3-story condo or cooperative wants to offer the membership the ability to waive or partially fund, in other words, less than fully fund, that remains an option for those buildings now and ongoing. If you're 3 stories or higher, your ability to do less than fully fund ends. The ability to have your membership vote to do less than fully fund will end December 31st, 2024. Okay. Again, they put in, if an association fails to complete a SIRS, such failure is a breach of an officer's and director's fiduciary duty to the unit owners. What is key here to me, and what is a little concerning to me, is if you recall, when it was the milestone inspection, if you fail to do it knowingly and willfully, you breached your duty. For one, whether it was intentional or whether it was just sloppy drafting, this provision under the SIRS didn't include knowingly and willfully. It just says if you fail to complete it, it's a breach of duty. So again, it's something that I'm not the only one who's mentioned that. We're going to hopefully get some clarification on that. And I would like to see knowingly and willfully added to here as well. But bottom line is, if you're a 3-story and higher building, then you need to be having the SIRS completed. And that SIRS study should be completed by December 31st, 2024. Okay. Now, as to the SIRS, and now I want to talk about being able to waive or not waive reserves if it's a unit owner controlled association. And again, this is a unit owner controlled association. Developer controlled is slightly different. As to the SIRS, the legislation is very clear. Unit owners may not vote for no reserves or lesser reserves for items set forth in the SIRS report. And that's after December 31st, 2024. So I want to point out to you what that means, in my opinion, and the opinion of others. And I will say that this was presented to the DBPR, who confirmed their position is the same as what I'm about to say. So I think there's a level of comfort in understanding that that this is, at least as of today, the proper interpretation. The statute says that you may not waive, or I should say the statute says you may not vote for no reserves or lesser reserves. In other words, you need to fully fund reserves that are part of the SERS after, and it says you cannot do that after December 31st, 2024. So it's November 16th today, and I know many communities that I work with or I've spoken with, they are doing their budgets or finalizing their budgets or have already finalized their budgets. And as part of that, if they were looking to do something other than fully funding, and I will, a lot of communities have moved toward more, to try to move toward full funding now, but some others are ramping up their funding, which is totally understandable, as we've already talked about all the other financial situations. So you take a vote. Let's just use today. So today's November 16th. Say you have your membership meeting today, and you've asked the membership, hey, would you like to less than fully fund? And the members, or we can either fully fund or we can fund it 10% this year. And the membership votes to say we're going to go 10%. Now, fast forward 2 years from now, it's November 16th, 2024, and you do the same thing. Hopefully, though, you've increased your reserve field a little bit more, but again, business decisions with the understanding that you're going to eventually have to have things fully funded. But 2 years from now, November 16th, 2024, same vote, same question is posed to the membership. Would you like to less than fully fund these SERS reserves? I'm calling them. Okay. And the membership says yes. So that means in 2025, the budget that is approved can have less than fully funded reserves for the SERS because the vote was taken prior to December 31st, 2024. So let me be clear. Let me repeat that because it's something that people keep asking, and I want to clarify. The statute says that the membership will not be able to vote. I'm paraphrasing. Will not be able to vote to less than fully fund after December 31st, 2024. So if the vote is taken prior to December 31st, 2024, even for the 2025 budget, which is what it would be for, that vote is valid, and that budget can have less than fully funded. So the first budget you would have that could not have less than fully funded would be your 2026 budget. Okay, I hope, if I'm in person, I'm asking if that's clear to everyone. So I hope that's clear, but I think it's a very important point to reiterate. Okay, if you are less than 3 stories, there's no question you can, as I mentioned, you can waive reduced reserves for items that are not part of the quote SERS, but less than 3 stories, you have reserve requirements for roof and painting. And roof and painting are items that are listed in the SERS. And the way Tallahassee drafted the statute, they did not say you can't waive this for the SERS. They said you can't waive for items in subsection G. And subsection G lists painting and roof, for example. So we want clarification of what Tallahassee's interpretation is, what they meant. Did they mean to say that nobody can put a vote of waiving reserves for roof and painting? Or did they mean to say that if you are less than 3 stories, you just uniformly follow the quote unquote old waiving of reserves laws? So that's what we're looking to get clarified. But none of that will apply before 2024. So if you are less than 3 stories, you are under, in fact, any community, any height for 2020, this year, 2022, next year, 2023. And again, as I mentioned, in 2024, you can operate without being mandated to have fully funded reserves at all. I'm not suggesting that's your best business call, but I'm not your business advisor. I just want to let you know what the law says. Okay. If you're in a developer-controlled association, they made some very significant changes. Before turnover of control by the association to the association by a developer to the unit owners other than the developer-controlled association may not vote to waive reserves or reduce funding. Previously, the developer had up to 2 years. They could waive all reserves following the recording of this declaration. So this is a big change. There's no more waiving or reducing the funding of reserves in a developer-controlled association. Okay. As far as official records, the structural integrity reserve study, the financial report of the association, a copy of their inspection report, and any other inspection report relating to structural or life safety will be part of the official records and open to inspection. Structural integrity reserve studies I mentioned earlier must be maintained for at least 15 years after the study is completed. And any inspection report and other inspection report relating to that must be maintained for 15 years after receipt of the report. They did add a quick change here. In addition to the right to inspect and copy the declaration, bylaws, and rules, a renter also has the right to inspect the milestone inspection and structural integrity inspection report. Okay. As I mentioned earlier, the inspection reports must be posted on the website if you have that website obligation. Okay. And now and also the jurisdiction of the DVP, the Division of Condominiums, Timeshares, and Mobile Homes, which is the division that oversees the part of the DBPR. They have enforcement and compliance authority. They have now, if it's pre-turnover, they have jurisdiction to address complaints related to procedural completion of milestone inspections. Post-turnover, they now have all, in addition to their financial issues, elections, and maintenance of and unit owner access to records, they also have a jurisdictional authority over the procedural completion of the SIRS. So if you don't have a SIRS being done, know that your owners can complain to the division, and they will, at no cost to that owner, and the division has jurisdiction to now investigate and issue monetary penalties if you are not in compliance. Okay. New reporting requirements for all condominium and cooperative associations by January 1st of this year, excuse me, January 1st of 2023. Any condominium that existed or cooperative association that existed on or before July 1st, 2022 has to provide some basic information. The handout will give you the email if you, the division did create a form, but you can send an email with this information. You can do it in a Word document and attach it as an email. And really what they're looking for, the first item says the number of buildings on the property that are 3 stories or higher in height. And if the answer is none, then you're done with the form. So of course we posed this to the division. We said, are you looking for people who are less than 3 stories to just send you in none, none, none? And of course their answer is no, we don't want that. Well, then they need to take that up with Tallahassee because the law says all. So if you are 3 stories or higher in height, each building that's 3 stories or higher must be listed on this form. So if you're a multi-condo, the number of buildings that are 3 stories in height should be noticed, how many units are in each of those buildings, the address of each of those buildings, and the county where those buildings are located. So but if you are less than 3 stories, then you don't technically, I would say, I would send an email, put the name of your association, and just say, we have no buildings that are 3 stories or higher, and send it, print it, and save it in your file, you're done. Okay. Sellers of units. This is obligations to a seller of a unit. But you get the materials, you can go through that. But I'm not going to spend a lot of time talking about the sales process. But this is obligations for the sellers to provide copies of these reports. So if you are selling your unit or you're someone who works as in this area, be aware that this is also requirements there's applicable. Okay, so that is the major part of the presentation. And so now I want to just see if there's any other quick questions I can address on reserves. Okay, Rita Dever says, do condo boards now have authority to approve a special assessment for a structural repair rather than having to get a quorum of members to approve per docs? Rita, you're going to need to definitely get something in writing from your association counsel, but I will tell you informationally, if it's a structural repair as in necessary maintenance, whether your documents require a membership vote for a special assessment would be would be superseded by Florida case law. The courts have stated that if it's necessary repair, the board not only has the right but has the obligation to do those repairs and can fund it by way of adoption of a special assessment against the membership, even if the documents require a membership vote. Okay. Robert, you asked about 100% reserves on 1-story villas in January 2025. Again, the SIRS does not apply to the 1-story villa, so I think that answers your question. Lori, I don't follow the question. Okay, John, I addressed the question about the window sliders. We're going to hopefully get that clarified. Betty, Betty asked if the building was built in 66, burned in 82, which CO do you go by? I mean, it seemed like if the building burnt down and then they had to rebuild the entire thing, you'd go by the 82. But again, that's a question that would be need to be further confirmed. But I mean, I speak logically, and we all know that logic doesn't always win when it comes to questions of the law. Okay. Jerry, don't go just yet. There's more to come. Len asks, there is a sample matrix of the SIRS report due by January 1st, 2023. I am not aware of any such requirement. Charles, how will the state verify proper fully funded reserves? Bank statements to who? Great question, Charles. I mean, some of these are great questions, and I share them with everyone because these are questions that don't have at least don't have an answer from my point of view right now. I don't know. I can't predict how the division is going to what they'll require in documentation to support it. But I will say this. One thing that will be very helpful to all of you if these questions come up is that you've had a reserve study undertaken and you are following the guidance of the reserve study advisor, calling them the expert, or your engineer, the engineer doing that reserve study. If you're following the guidance of them, I believe you should have no issues with what you're doing, so long as you're funding in accordance with what you've gotten. Sean, you will be getting the copies of this webinar presentation. Yes. Warren, do condo boards under 3 stories have the right to require full reserves now? Warren, yes. As I mentioned earlier, any board, the board of directors has the full discretion, regardless of the number of stories you are, to fully fund reserves every year. The law says that the budget is proposed with fully funded reserves. And it's adopted that way unless the membership has voted to less than fully fund. That membership vote is at the discretion of the board. If the board believes it's in the best interest of the association, of the community, to have fully funded reserves, that is totally legally within your discretion. As I always say, legally 100%, politically maybe not popular, but legally it is 100% within your discretion to not put the vote out to less than fully fund and require fully funding of reserves. Okay. Lewis asks, you mentioned an association can vote before December 2024 to reduce reserves for the 2025 budget. Can the association vote to waive reserves, have no reserves before December 2024 for the 2025 budget? Yeah, Lewis, I'll be very candid. I speak of less than fully funding as opposed to waiving because in my opinion, and you can tell me we don't care about your opinion, but in my opinion, it's important that it's not in the best interest of any of my clients or any of the communities I'm talking to you about now to not have some reserves in place. And so I don't talk in terms of waiving. But the law allows if the board wants to put a vote out to less than fully fund, which includes waiving, then that is something the board has the discretion to do. And the membership, if you put out, hey guys, do you want to fully fund or waive? You're almost invariably going to get waive. If you pull out, do you want to partially fund or waive? You're almost invariably going to get waive. If you put out, do you want to fully fund or partially fund? You're going to likely get partially fund. But the same information I gave earlier, if it's as long as the vote that's out to the membership is before December 31st, 2024 for the 2025 budget, that vote can be to do anything from 0 reserves up to 99% reserves. Yanid, any building, regardless of the age, that is 3 stories or higher is required to have the structural integrity reserve study. Yes. Okay. Those are some very good questions. I hope I answered them for the most part. I will circle back as we get toward the end because bear with me, guys. I didn't pick the content. That obviously is the biggest part. We spent over an hour on that part. These next few items, I will go through rather quickly. The state insists that I at least mention them. I do want to say, and because Ashley did mention this earlier, and I should have reiterated then, but if you're on here as a CAM and you want your credits for this class, Obviously you registered, but you're going to need to fill out the evaluation form. When the class concludes, there'll be a link that pops up for you to fill out the evaluation form. I ask all of you to please fill it out. I appreciate any, constructive criticism, any positive, positive, but any feedback you have that would be helpful. Obviously, if your community is in need of any legal assistance, and that's something, there's an area on there you can note. But more importantly, for your managers, you need to make sure you fill out that evaluation form and sign it with your CAM number so that we have the sign-in sheet and that form to be able to give you your credits. Okay, and so, but I will go through these next few items a little bit more quickly is my intent, and so I can circle back to these other questions. But do remember, this is what I'm required to do. So residential picketing, dwelling, as used in this section, means a building structure or portion thereof which is occupied or designated or intended for occupancy as a residence by one or more families, and it's now unlawful for a person to picket or protest before or about the dwelling of any person with the intent to harass or disturb. Okay, that's again threshold. It's with the intent to harass or disturb that person in his or her dwelling. Before now, and whether if you're a person or group picketing or protesting in front of a home, I don't know what other intent you'd have. I mean, you're saying, hey, I'm not here to harass or disturb them. I'm simply here to, bring to attention my opinion. Again, that's something though, but they have put in, there is an intent. So there is a threshold there that they have to, if they're going to be arrested for violating the section, they'd have to meet. However, before you may be arrested for violating the section, law enforcement or military enforcement must go as near to the person as may be done with safety, and shall command the person to immediately and peaceably disperse. So if you are doing this and they come up to you and say to you, hey, you need to stop doing this, and you walk away, you should not be in and have any issue. Otherwise, it's a secondary misdemeanor violating this section. Okay. This now, this focus is primarily for those HOA owners listening, single family homes. A few years back, we had a bill on tree pruning, trimming, or removal on residential property, where basically what it said was that if the tree was on residential property and it was going to be cause damage to person or property, that the association or an individual did not need to go to the local municipality, get involved with all the red tape to ask for a permit to remove this, nor did you have a requirement to replace it. Okay, so and that had been in place for a while, but there was a pushback, and my understanding is from two groups, League of Cities, and an arborist group that pushed back on this, and I think for different reasons. But the League of Cities, obviously, I think it's a financial situation there where they're losing a lot of potentially losing a lot of permit fees. The Arborist Society, having spoken with someone there, was claiming that there was fraudulent activity being undertaken where people were ripping trees out just because. I don't know if that's factually accurate or not, if there was a situation or two, but unfortunately, they got the ears of the right people in Tallahassee, and they've modified this provision. I'm going to explain to you why this becomes more relevant. They added two terms, documentation and residential property. And the documentation term is really just to clarify what is actually needed, to make it a little bit more stringent on what you need to document in order to be able to remove the tree. On a personal level, I don't have an issue with that. Residential property has now been defined as a single-family detached building located on a lot that is actively used for single-family residential purposes that's either conforming use or legally recognized non-conforming use. So this is where I run into the issue. A single-family detached building located on a lot. They've narrowed the definition of residential property significantly, okay? And what this means is a practical matter to the homeowner association primarily, but it might impact a certain condominium or cooperative communities, but it's primarily the HOAs. You have trees in common area. Now, I have not heard a single person, and I have discussed this with the lobbyists or the attorneys who are representing these groups. Not a single individual has given me a good answer as to why the common areas of a residential community would not be considered residential. why you would narrow the definition to single family home and not, not include the common areas of that same community. And what this means essentially is, and I gave a true example, my community, where the swale is technically common property, even though I have to maintain it. So if there's a tree on my lawn ripping up the sidewalk, so it's damaging property and obviously also a risk to people walking by, and quite frankly, making it impossible for the association who maintains the sidewalks to get insurance, I can take that tree out. I don't have to go to the city for a permit, deal with all the red tape, and nor do I have to replace it. But if that tree is 3 feet across the sidewalk in that swale, then all the red tape has to go through, has to be somehow replaced. All these issues come up for the same exact scenario. It's illogical to me, and I mentioned earlier, logic doesn't always control, but I want you guys to be aware of this particular bill. And quite frankly, I don't even think the state said we should mention this particular bill, but I included it because I think it's important. And if you are managing an HOA community or board members in an HOA community, be aware that now if you are looking to remove dangerous trees that are on common property, you're going to have to go through your municipalities to get the permit, and you're going to have to talk to them about what you have to do to replace. If it's a single family home, you still need to get the proper documentation, and that's set forth in the statute. And it's, I reiterate it here. So you'll have the printout, but you'd be aware of that. Okay. Lodging standards. This is something they want to talk about, which is Maya's law. This was obviously a very, very, very sad, tragic situation where a young woman who was from South Florida was murdered in her apartment by an employee of a public lodging establishment. And I apologize if I have the facts slightly off, but generally speaking, I think that's correct. And so now there's this Maya's law has been created where a landlord of a public lodging establishment must require each employee undergo a background screening as a condition of employment. It's unfortunate that laws have to be passed to have this in place, but it is what it is. Background screening must be performed by a consumer reporting agency, and it talks about what's has to be included in the screening. And it does now allow a landlord of a public lodging establishment to disqualify a person from employment if they've been found convicted or found guilty of, or even entered a plea of guilty or nolo contendere to any of the following, regardless of the adjudication. This is relevant in that this law is saying you can disqualify a person for these being convicted or found guilty of, or even if they pled out on these, which is somewhat different than the fair housing issues we can run into when you're looking to approve or disapprove an applicant to purchase or lease in a community. So please be aware of that significant and important distinction that this applies to disqualifying a person for employment. This is not the same as if you're looking to have, if you have the ability to approve or disapprove a sale or lease, and you're looking to understand what are good cause reasons. Anything that touches fair housing, I talk to you managers, I talk to you boards, get your experienced association counsel involved. Okay, do not wing that, because that just unnecessarily exposes the association, possibly board members, possibly management, to claims of fair housing discrimination, which can be avoided. Okay. There are a bunch of requirements that they've added directly in response to that event. Okay, a landlord has to give at least 24 hours reasonable notice before entering the premises to do any repairs. There's requirements for issuance and returning of dwelling keys and regulating storage of unissued keys and maintaining a log for those keys. Okay, so keep that in mind. Building regulation, permits. There are new requirements for building code inspectors and plan examiners that I have now talked to you about, and I'm going to send you these materials that you can review. I'm not going to spend a lot of time going over this. If anyone has any questions on these, I throw it in the Q&A and I'll circle back to it. This has to do with demolition permits and what's permitted and not permitted, and for municipalities to allow for demolition permits. This has to do with certificate of occupancies and this is only going to be relevant in the condominium world, cooperative world, if you're a new building. If you're a single family or two family dwelling, then and you're having it's all again new construction. So if there's any sort of new construction questions, then we can circle back to it. I put this in here because I knew I was going to have you sent the materials. This is sort of a roadmap that will go over, I don't need to read this to you. You guys can go through that. And I think you appreciate me doing that. Okay, the last thing, Bill, I want to talk about Senate Bill 2D, which is the insurance. And again, I'm not going to spend a lot of time on this, only because because most of it really doesn't have any application to the association world. It's relevant to single family homes and single family home owners, but it's not necessarily the association, because in most single family homes, you the owner are responsible for the insurance of your property in windstorm and things of that nature. So they had this special session to address insurance and try to provide relief in the insurance market. I think I can fairly say that there was little to no relief provided to the condominium and cooperative world as part of 2D, and a little bit to the HOA world. So that's why, again, I guess there's a reason why 6 months later, or however many months May to December is, that they're going to be coming back and doing another special session. But they created a reinsurance to assist policyholder program that authorizes a $2 billion reimbursement layer of reinsurance for hurricane losses. Obviously, we had that significant event after this was passed, which we'll see how that impacts the insurance market for all of us. They created a My Safe Florida Home program to provide financial incentives for Florida residential property owners to obtain free home inspections, to identify mitigation measures, and provide grants to retrofit those properties. They apply to single family homes with a value of $500,000 or less that are located in wind-borne debris regions, which are set forth in the Florida Building Code. So there are specific qualifications. And this took effect July 1st, and it is scheduled to sunshine or expired October 1st, 2024, unless they renew it. These are the criteria, additional eligibility criteria for the My Safe Florida Home, and also how they've allocated funds, which you can certainly review on your own. And like I said, if you have follow-up questions, you can reach back out. This part I wanted to touch on, the contractor solicitation of roof claims. This is where, in my opinion, from my observations, this is where the Tallahassee focused a lot of what they try to do. They try to basically reduce insurance costs to insurance companies by limiting or eliminating what they're seeing as quote unquote fraudulent claims by contractors that are that they are saying, this is not my position, they're saying that they were fraudulent. There are a lot of not fraudulent claims or over exaggerated claims that are also the adjusters and the attorneys who do this type of practice are causing these increases in costs. So they really focused their efforts on minimizing the ability for these types of claims. So there's prohibited advertisement policies that they added, and advertising by a contractor that encourages, instructs, or induces a consumer to contact a contractor or public adjuster for the purpose of making an insurance claim is prohibited. If it states that the consumer is responsible for payment of a it's amended to require that any advertising has to say the consumer is responsible for payment of an insurance deductible. It has to say that it's insurance fraud for a contractor to pay, waive, or rebate all or parts of an insurance deductible applicable to a payment. It has to state it's insurance fraud punishable as a felony of the 3rd degree to intentionally file an insurance claim containing any false, incomplete, or misleading information. So those now are required to be in any advertising. Okay, there's some annual reports that have to be filed by the Office of Insurance Regulation that they wanted us to make you aware of. And this is relevant to if you wanted to research property insurers in the state. Okay, separate roof deductibles. It add an amendment to allow an insurer to include a separate roof deductible in a personal line residential property policy, so long as the insurer complies with specific statutory requirements that are set forth. Okay, if you have a separate roof deductible, no other deductible under the policy may be applied to the loss. Okay. Okay, this is just additional requirements for a separate roof deductible. There's language that they're saying must be required notice to policyholders. You're electing to purchase coverage on your home, which contains a separate deductible for roof losses. Be advised, this may result in high out-of-pocket expenses to you. Please discuss with your insurance agent. Which is interesting because that's very much like the language you're required to put on your ballots and proxies if you are looking to have the membership vote to less than fully fund reserves, waive reserves, or use reserve funds for another purpose other than what they were designated. You have that big bold font that says, by doing any of these things, it may result in a special assessment. So it's similar to, they're giving you this, they're requiring that the carriers give the insured that type of disclaimer. Additionally, a roof deductible policy will not apply if it's a total loss to the structure, or if it's a roof loss resulting from a hurricane, or a roof loss resulting from a tree fall or other hazard. The bottom line is there is, without getting into this is something, if you are of the mindset, discuss this with your insurance agent and find out if this is something that is worthwhile to you. What are the pros and cons? It might be less expensive, but there might be exclusions or things that will that may not be worth the difference in price. So really, that's the point. Price it out and figure it out. Roof inspections and limitations. This is relevant. I know this is relevant to the condominium world because I've had to deal with it. Okay. It prohibits an insurer from refusing to issue or refuse to renew an HOA, a homeowner's insurance policy. And I apologize. When I said it applies to the condominium world, I will clarify that statement in a second. This is specifically referencing a homeowner insurance policy that require insuring a residential structure with a roof less than 15 years old solely because of the age of the roof. Now, it's talking in terms of the homeowner policy. So let me circle back. I have, it is saying it's insuring a residential structure with a roof. So you really need to confirm with your agent whether this applies. I have had some condominium associations who have been forced to go under Citizens, and Citizens required them to repair their roofs. And even once they repaired the roofs, Citizens said, you know what, never mind, you need to replace it. And that wasn't right, by the way. And we were able to assist that particular association with getting Citizens to honor their original word, because the association spent an upwards of $30,000 or $40,000 to do the repairs so that they could get their coverage. So Citizens did relent and did ultimately give them the coverage. But you're going to want to make sure, you're going to want to very much document in writing what your requirements are to renew coverage or get your coverage back, including from Citizens. Whether repairs are sufficient or whether you're going to need to replace. And if they say you need to replace, well, then we have to ascertain whether there are portions of the statute that are applicable. But what it says here, an insurer cannot refuse to issue or renew a policy insuring a residential structure with a roof less than 15 years old solely because of the age of the roof. Okay, if the roof is at least 15 years old, then you have to be allowed to have a roof inspection performed by an authorized inspector at the homeowner expense before requiring replacement of the roof as a condition of issuing or renewing the policy. Okay. Effective January 1st, 2023, property insurers are required to conduct any physical inspection of a property related to a claim within 45 days of receiving proof of loss. And it's within 7 days after assignment of adjusted the claim, there are certain timeframes. So this takes effect January 1, 2023, and it's trying to streamline insurance claims handlings, because that was another issue that was talked about, is how, and again, from the, to me, this is appropriate because from the insurance company side, I think they tend to drag these things out, not uniformly, but I'll drag these things out. So there's got to be a little bit of give on both sides. And like I said, the statutes definitely were attacking, or we're not attacking, we're addressing, is a better word, the concerns with regard to contractors, adjusters, and attorneys who had put in roof claims. And this is now the other side of it, saying, hey, insurers, you have to provide a reasonable explanation of a claim decision And if the insurer makes a claim payment less than contained in the insurer's adjuster's estimate of loss, there has to be explanation of discrepancy. So there's putting some limitations. And this is the part about the attorneys, that they address the attorneys. A new standard for the award of an attorney fee multiplier. Okay. Attorney fee multipliers may only be awarded under rare and exceptional circumstances. Otherwise, attorney fee awards are going to be based on the number of hours reasonably expended on the litigation multiplied by a reasonable hourly rate for services. Okay. A defendant insurer may obtain attorney fees and costs associated with securing a dismissal without prejudice. That means a dismissal, that meaning without prejudice means it could be brought back for the plaintiff's failure to provide the required notice of intent to initiate litigation at least 10 days before filing suit. So what this is telling the attorneys and the claimants, though, if you believe that you are not getting treated properly by the insurer, they're denying the claim or paying less than the claim, you need to give them a notice of intent to initiate litigation at least 10 days before you file that suit. If you fail to do so, that is an automatic basis to have that complaint dismissed without prejudice, meaning that means it doesn't go away. What it means is it's dismissed, and then you have to properly send the proper notice, give it at least 10 days, and then if they don't comply, you can refile. But the fees and costs associated with securing the dismissal, the individual would have to be responsible for paying. Okay. This is another way they're trying to crack down. This prohibits the assignment of the right to obtain attorney's fees in suits arising out of a property insurance policy to persons other than a named insured, one covered by a provision in the policy that's not specifically named, or a named beneficiary. So the result is that assignment agreements may occur, but the assignee, the vendor, no longer is able to recover attorney's fees in suits against an insurer. So that's a big one, because that was a big complaint they had. The complaint and the statistics are that they presented were quite, crazy. Where they said that you'd have, and I'm making this up, so it's going to be off, but you had awards that 90% of the award, of which a substantial part of that award was not going to the owner, was going to the adjuster and or the attorney. And I will say, that if the insurance carrier is aggressively defending and then ultimately loses, there are going to be big attorney's fees. But what this is saying now is that attorney's fees are not going to be recoverable on an assignment. So that's going to make it less likely that these third-party vendors are going to want to take these assignments and push for just collecting fees. Okay. The property insurer stability unit reporting requirements, you can review those on your own. And so that is the last of what I have there. So we have 15 more minutes. So what I'll do is I will scroll through these questions and see if there's any more that I could answer. I want to thank everyone, though, for taking a couple of hours to be with me today. I hope, I do prefer these in person as much as possible, but I want to thank Ashley and Campbell for giving us the opportunity to be able to present it to you all this way, because that is very, very helpful. Hi, Ashley. And I am going to answer I'm going to try to answer some of these questions, Ashley, but just in case anybody needs to get going, I want to remind you again about the link to the survey. Yep. And please make sure that you get that completely filled out, sent back, and and this survey, this feedback that Ashley's putting up now is separate from the survey you'll get in the link, just so we're clear. That's something we'd like, some immediate feedback, but you will get an actual survey from my office, which you're required to complete I'd like you to completely fill out. And if you're a board member, I'd like you to make sure, a board member, please fill it all out, and answer all the questions there, give some feedback. If you are a manager that wants CAM credits, absolutely fill it out, sign the bottom, make sure we have your information. And Carla, Jeff Solomon, Carla Ramirez says it kicked her out. Can someone send the links for the survey again? So Carla, we will get that taken care of.
Yeah, just real quick, Michael, and then I'll let you do all the questions. I just want to make sure. So the link will automatically pop up, but just in case you closed out of it, I'm actually going to include the link for the evaluation that KBR needs for your credits. I just put it in the chat. So click on that link just in case if you're unsure where it'll be. I just put it in the chat so you can access the link for the evaluation that you'll need from KBR to get your credits.
And yes, our poll that we have up, I launched that separately. So there's 2 separate things. I just want to say thanks to Michael. You did a great job. I will be sending everything out after. So the recording, the presentation, Michael's contact information, and also a list of our upcoming events. So I'm going to stop my video. Michael, go run with the questions, and thank you so much.
Thank you again, Ashley. Thanks to everybody over at Campbell. Love doing these programs with you guys. You do great about getting education out, and obviously KBR shares that desire. All right, so let me try to knock off a few more of these questions. Warren, when is full fund? Now, some of these questions were asked in the first 15, 20 minutes, so I think I might have already answered a lot of them. So when is full funding of reserves required for less than 3-story condominiums? Warren, it is not, there's no definitive mandate on that. Right now, the only open question is whether the less than 3 stories are able to less than fully fund the roof and the painting, which are part of the SERS. But for now, nothing takes effect before end of 2024. So if the board wants to fully fund, the board can fully fund. If the board wants to give the membership the opportunity to vote to less than fully fund, make sure it's done properly, but you still can do that. China, the reports do have to be provided online, but it's not the only way it can be done. And that's because not everybody reads the website. Gene, is there anything in SB4D that applies to condominiums that are not 3 stories or higher and not within 30 miles from the coast? Senate Bill 4D is, again, Gene, I'm going to say that the intent of Senate Bill 4D was to apply to the 3 stories or higher. And so the answer is that there is really nothing in that bill would impact the less than 3-story building. Because like I said, the reserve portion of that is no different than right now than what the reserve requirements are for your building. So that hasn't changed. Yeah, Scott, I can't answer I don't know if the fact that you just completed your 50-year recert, would it satisfy the requirements? I wouldn't think you need to do a whole nother building inspection, but as I mentioned earlier, you need to talk to your engineer, find out from them what it would take to just meet the milestone inspection requirement based on what they can do with that prior report, and go from there. Vanessa, if the building's from 2007, is the initial milestone inspection still due by 12/2024? No, if you are within 3 miles of the coast, it would be due in 25 years, and if not 30 years. So no, an initial milestone inspection is not going to be due. The SERS is required for all buildings, but the milestone inspections, that's going to depend on the year your CO was issued. Good question, Vanessa. Ron Arani, I don't know if that's average. That I'm not the one to ask about pricing. That would probably be best directed to your management team as well as your fellow board members in the area as far as what pricing is. Barry's saying Broward and Miami-Dade approved their 25-year recert. Thanks, Barry. It still doesn't address, but the question that everyone wants to know is how does that impact the milestone inspection? And that's a question we need clarification on. Bob says, how soon after the phase 1 report do we have to have the phase 2 inspection? And Bob, I guess if you have the phase 1 report and they don't need a phase 2, then obviously you don't need to have that. But you have 180 days to have the milestone inspection completed from when you get noticed. So both phases would be done within that time frame. Clint, how often will the SIRS studies need to be updated? Every 10 years is what the statute says. My advice, my opinion is that 10-year window is just way too long. I think that I think you should be considering updating your reserve studies much sooner than 10 years. But that is my opinion, and it is ultimately a business decision for the board. Marvin would like us to provide the form to notify the state on the properties. Marvin, send an email, if you would, to info@kbrlegal.com with that request, and so I can send that over
And
to
Michael, we have a link for a
Oh,
complimentary
perfect.
form we created on our website under the links section at kbrlegal.com.
Okay, Marvin, please go to kbrlegal.com, or anybody who'd like to do that, and there is a links section that will give you that form. You could print it out. Perfect. Thanks, Jeff.
You're welcome.
James, I'm happy to ask the creator of that template if I can share it. If you would send me that request at info@kbrlegal.com, that would be helpful. Ken, you can certainly do inspections prior to getting notice from your local authority. I don't know that you want to, but you could. How do we measure the 3-mile rule, Diane? I share your question. Again, if your property is close to, like, within that 3 miles, then obviously that's something that you're going to definitely need to get clarification on. And like I said, for one reason or another, that is something that they are definitely discussing in Tallahassee as far as clarifying. Let me jump down here and see if there are any other questions. Okay, Jeff Solomon?
Yes.
Yeah, there was a request. Thank you, Jeffrey. There was a request can we just email blast that form? I don't think I want to email blast it out because I don't think everybody wants it. I think the better move, Jeff, if you could put the link on the Q&A. Can you just add the link that people can click to it, please?
Sure.
Thank you. David Friedman, the statute does not require a reserve study be done every 5 years. There is no requirement in the statute for a time frame on the reserve study. Thank you, Dominic.
And the only way for me to put that in the Q&A is
Okay.
I went back and answered Jeffrey's question, even though you already sent it into the queue. So it's under his question. As a panelist, I cannot pose a question. It won't let me do it.
Well, Jeffrey is still there. Just pose the question. Just ask about the form again, Jeffrey, so we can pose it, give it to everybody. Dominic, you post your CAM number on here, which we appreciate, but you're going to have to fill it out on the survey. Please be sure you do that.
Ashley, if you can, I put that form that Jeffrey asked about into the chat. Are you able to share that with everybody so everybody can see it? I just shared it with you and with Michael.
Here, I'm trying to select it.
Thank you.
Okay, and Jeff Solomon, Dominic Vaccaro had said, do not see where to sign and give my CAM. So that is you can answer that question, please. I think that's on the survey, right?
That's probably the evaluation. As Ashley mentioned, when we end it, when Ashley ends the webinar, or if you choose to leave on your own, you get a little window that pops up. Little window has a link. You click on the link and it takes you to the evaluation. And also on that evaluation, there's a link, a button at the top where you can actually view and download and save these slides that were used today as well.
And I did just put that in the chat too.
Thank you.
Yes.
You're always on it. Thank you so much.
Barb asked, does the law require background checks for renters? The Maya's law was not addressing renters. Maya's law was addressing employees, people that the landlord was bringing on board to do maintenance and other things of that nature. It wasn't about the renters. So the law doesn't require that. The associations might, hopefully landlords would, but not the law. Well, not this particular law. Carla says, I'm not a robot, portion is not working, keep spinning, won't let me submit my survey. Someone needs to let, Judy, as far as my Miles law is in effect today, I believe it took effect already.
Hey, to that point about the spinning, this is kind of like when you go on a Ticketmaster and everybody's trying to purchase the concert tickets when they go on sale for the first time for Billy Joel. And so many people are trying to do it at one time that it may get bogged down. Save the link, try it again later. And I know Ashley sends out a follow-up email the following day or so as well. That link will be there. And if all else fails, email us at info@kbrlegal.com and we'll help you out. But it's more than likely just several people. We had about 500 here today trying to do this at the same time.
Thanks, Jeff. Gene, does the board have to offer to the owners the opportunity of waiving reserves? I think I did answer that after you asked posed that question. But just to be clear, the board does not have to offer the owners the opportunity of waiving reserves. Absolutely not. It is within the board's business discretion to say that we believe it's in the best interest of the association that we fully fund reserves this upcoming year, and they adopt their budget with operating and fully funded reserves. Sal, I think that's a good plan. Glad you came. All right, guys, I see it's now 1:57, and I know there was a bunch of other questions. I tried to get through as many of them, and I hope you guys appreciate that. Beth, I don't know if I answered your question because I don't know what it is. Let's see. Hey, Mary, you're going again. You're asking, does the 25 years supersede 40 whether city or county? And again, this is one of those open questions. I understand why you're confused, and it's not a question that me or any I know we work together, but even as association counsel or any lawyer can give the definitive answer to that question. It's something we could investigate and ascertain and get someone to document in writing what is required, what's not. Part of the confusion, and again, this is pretty much just in Broward and Miami-Dade, is, hey, we have these certification requirements, whatever they are. They were 40 and plus 10, and Barry's saying I know the Miami-Dade and Broward had talked about 30. I didn't know that they were. I thought they were still in readings. I didn't know they were officially approved. I missed that memo, but Barry's on the ball, so I trust him. But regardless, whether it's 30 year, 40 year, 50 year, whatever it is, how does that impact the milestone inspection? And I agree with you. There's confusion. There needs clarification, and hopefully we'll get that clarification. But my recommendation to you and anybody in your similar situation is in this case, you're saying City of Hollywood. Good luck. Ask from the City of Hollywood, and your engineer is saying that the 25-year inspection supersedes. Well, let's get that in writing from the engineer. Let's take that to the City of Hollywood and find out from the City of Hollywood what they're saying. And then, to the extent you need to get legal counsel involved, that's where where an association counsel can step in and try to get some clarification. But I think it's unfortunate that even the municipalities are confused. And there's these inspections are revenue sources as well. So. Hi, Michelle. If a complex is a 2-story by marina, again, a milestone inspection is not required for 2-story. Okay, Dominic, I'm not sure that what you were asking up there, but that was like over an hour ago. So I didn't say the 10-year inspection I never said anything about any inspection having no bearing on milestone or the other way around. What I'm saying is that is questions to be posed to the municipalities and to the engineers to clarify, because my understanding is the milestone inspection is not going to be satisfied simply because you've done these other inspections. That there's certainly a lot of overlap, but that if you've done those other inspections, you still need to make sure that you've met the requirements of the milestone inspection, and including the distribution of how it has to be distributed, that summary recommendation, which I don't know if a milestone, if the 40 or plus 10 years reports ever did that summary that is required by the milestone. So for example, that's an easy one to say if they never did. That's the kind of thing you need in a summary, that needs to also then be sent to all owners. And these things all need to be put on the website, so there's those requirements. And conversely, if you have the milestone done, does that satisfy whatever the municipality, and like Mary's question, will that satisfy, the cities? If you do the milestone, does that satisfy whatever 30-year or 10-year requirement they have? These are only Broward and Miami-Dade is dealing with that still. But those are ones that we definitely hope to get clarified. And part of the problem with that, though, is the state isn't necessarily the only one that can clarify that. The counties are going to have to clarify that. Okay, guys, it's 2:01. I'm going to jump off now, but I want to thank everyone again for being on here, asking great questions, allowing me the opportunity to chat with you for a couple hours. I hope you appreciated, or not appreciate, I hope you enjoyed, or quote unquote enjoyed. Hope you did at least take some good information. And that's it. Thanks again to Ashley and to Campbell. And thanks, Jeff Solomon, my guy there, for a background, make sure I was right. And everybody, happy Thanksgiving. Happy holidays. Look forward to seeing you guys in person, future events, and back here with Campbell as well. Thanks.
Thanks, everybody.
Thanks for watching. For more great educational content, click the subscribe button now.